There's just a minimal half point left over those 10 points yesterday. I had not read 368. Let's turn to it for half a minute.
Of the Constitution.
Of the Constitution. The amendments required would be quite merely the entries.
Three-fourths of the...
Three-fourths of two-thirds of Parliament
and
half of the states.
Yes, ratification.
That second part is even more cumbersome. Just turn to 368, longish. Clause 2. My lord is what?
First proviso. C.
Yeah. An amendment will be made only by the introduction of bill from Parliament. When the bill is passed by each house by a majority of total membership and majority of not less than two-thirds, they will also get two-thirds. It shall be presented, which shall give an assent to the Constitution, provided, my lord has got the proviso is addition, that if such amendment seeks to make a change in C, any of the lists in the 7th schedule, even list 1, the amendment shall also, the word also is important, require to be ratified by legislature of not less than one-half the states by resolution to that effect passed by those legislatures before the bill making such amendment is presented for assent. There's one last thing on yesterday's. I read 8 of my WS yesterday. I somehow omitted to read 26 and 27, which is connected. So I can just wrap it up on this by asking my lords to go to my submissions 26 and 27. That completes those list of points. As Justice Shah said, I'll be giving that list today, typed out. That's just 26 and 27. Just very short paragraphs.
Yes.
The contention that entry 41 is not available to UTs with legislature is belied by existing precedents relating to functioning of such UTs and their legislatures. 26. The argument that UTs, even with legislatures, cannot have services of their own and therefore do not have entry 41 available is belied by the manner in which UTs with legislatures, including Delhi, have functioned so far. Now that this 27 is important, it's not going to take your options there. It's a bookmark. You were reading it here itself. It is settled law that creation of posts and terms of conditions of service relate to entry 41. Yesterday I showed you several acts. They all relate to this. The citation is para 6. It is primarily the legislature, namely Parliament or the State Assembly, in whom the power to make law regulating the recruitment and conditions of service of persons appointed to public services and posts in connection with the affairs of the union or state is vested. The legislative field indicated in this article is the same as is indicated in entry 71 of list 1 of the 7th schedule or entry 41 of list 2 of that schedule. 28, my lord, is ready. My lord remembers those Delhi Fire Act and several other acts I showed. So I'm not reading that. So these are ballots. Each para 28 is each manifestation of entry 41 being exercised. I'm sorry.
Has the UT constituted any services at all? Like central secretarial services you have? And of course, the All India services, and then the Dimanshu services.
Denics.
Are there any Denics? Yes, now it's Denics. Are there any services constituted by the state at all?
Well,
any act passed with respect to the state?
No act is passed to suppress the
Not even passed.
But all these acts create services. I mean, your lordship is asking, is there a services act?
General.
No, but there is no need to just as Delhi Minorities Commission, Delhi Lokayukt Act, Delhi Fire Services, all of them create a whole staff setup, a whole services setup under that.
No. Council, the question is, any of the law related to entry 122 and 28, 1, 2 and 18?
The power to create, but I'll tell you, just kindly tell me, answer.
No, nobody can dispute the power under entry 41.
Yes.
But the question is with respect to any law laid down or any law enacted with in connection with entry number 1, 2 and 18?
For example, section 6, 7, 8, 10, 11, 14, 16 and 63 of Delhi Fire Services Act. It creates posts it creates employment terms, everything. They have no power to create that unless the power is traceable to 41.
Well made.
What my lord is saying is a separate act.
Slightly different thing.
Point is taken.
That point is, you've already made.
Correct.
That there are several enactments of the Delhi Legislative Assembly under which posts are created.
41.
Therefore, that's relatable to NC.
So that's one answer.
But
There is no separate act which says Delhi Subordinate Services Act.
This point is a little different, which is that in respect of subjects which relate to entries 1, 2, and 18, if you are creating posts, if you are creating services, then perhaps.
Whereas there, your lordship will take it. Your lordship asked a question yesterday. A, it doesn't arise here. B, I am not asserting legislative or executive power to create posts for land, police, and malas.
Then there's
So
no-
that part, I may assure my lord. I mean, I'm sorry, I misunderstood the question. As your lordship may take it. A, it is a hypothetical question. In some malas case in the future, your lordship will decide. In this case, I am not asserting any right, legislative or executive, to do something for 1, 2, and 18.
Including creating of the post,
Including malas related.
including the services with respect to 1, 2, and 18.
Malas, including services meaning creation of post directly relating. If it is malas, everything is related to land, something is peripherally otherwise, no, I'm not asserting. Malas, take example, land revenue. Land revenue is Delhi is having all the stuff. But that doesn't mean that land I'm asserting. So malas, I'm strictly relating to 1, 2, and 18, which is amplified by 64, 65, 66 also.
land revenue is a separate entry anyway.
Yes. So therefore, malas, that will not trouble your lordship.
Anyway,
I am saying the reverse point now. I am saying that whatever I have created, unrelated to 1, 2, and 18, is relatable only to 41.
My question was, with respect to unrelated to those 3 excluded provisions,
Yes.
the general services, is there any general law that
That's
you
the
have
second
made?
question. There is no general law.
Number 1, are you also regulating the services under 309 rules? Have you made 309 rules?
Malas, we have not.
I'm just asking you.
Answer is actually no. There is no general act saying Delhi subordinate services or Delhi something.
So therefore, with respect to the disciplinary or other aspects relating to that, which are the rules which govern them?
Exactly. I'll tell you. We have mentioned them in my.
Well, the CCA rules,
Yes,
do they apply?
Let me explain to you.
Doctor,
So-
before you explain,
Yes.
what is DSSB about?
I beg-
DSSB, Mr. Mehra will assist you.
Which,
DSSB, Delhi Subordinate Services Board. Mr. Mehra, what's that about?
That's about, Milords, all these,
Appointments of what cadre?
Milords, I think it's
It's a board for appointment.
it's a board, Milords, we'll just find out, we'll take instructions.
DSSB.
But there is a DSSB in Delhi, which has been functioned for.
So that's how you appoint teachers, that's how you appoint other staff through the Delhi service elections.
Just as. I have understood my lord. Services like say in Gujarat administrative services, Gujarat subordinate services, etc.
There's nothing
There is
like that.
none in Delhi. Lord, all employees, right from All India services till downwards, Lord, except DAS, which your ladyship said, are recruited by UPSC and governed by the central laws and the rules framed by the Honorable President in exercise of proviso under Article 309, which I'll explain. So far as DAS is concerned, Delhi subordinate services, that is, the selection is not by UPSC, but by a separate service selection board, which is under the President of India. So for Delhi, there is no separate act providing for creation, selection, abolition, or departmental inquiry or any other service related issues by Delhi. Factual. Then whatever are submissions I'll make.
Now, so let me just summarize. About the specific case of DSTV, we'll get the act and read it to your lordships. Number 1, I am not asserting any right to 1, 2, and 18. That part is question 1, which came yesterday also, and I'm making it. Question 2, there is no separate act in the manner in which my Lord Justice Narasimha put the question. Answer is no. Point number 3, the issue is a little different and it is being conflated. There are 2 services we all accept, All India service and central government or DANIX or DANIX service. All such services are dual services. They are joint cadre services. They cannot operate without a state union territory on one side and a central government on the other side. That's important. In a joint cadre service, otherwise, your lordships would have no state allowing a joint cadre. The post is an all India service, but is always anchored in a UT or a state. That's the point. State is just like UT for purpose of anchoring it. Number two, and number three. Under that, once the overall board allocates Mr. X to UT Delhi, that person is based in Delhi, belongs to, for example, DANIX or belongs to DANIX. And his transfer, control, dealing with him, all comes under the existing system with the Delhi government.
Now that part,
yes,
under which all once allocated to a state
yes,
or union territory, all incidents of the service fall within that state or union territory.
Yes.
That would be referable to that legislation under which that service is created. Now, IAS, for IAS.
There are only two. One is All India, one is DANIX and DANIX.
Right. Now, therefore, we will.
They all have cadres in state.
Therefore, we will have to look at the rules under which that service is created. Admittedly, these services are created by either a central legislation or by rules and are governed by rules framed by a government of India.
So that we've dealt with in my submissions.
So therefore, we will have to look at the IAS rules. We'll have to look at the IPS rules and the rules which govern DANIX and DANIPS.
So that I will be showing to your lordship.
Right.
But one thing I was saying, apart from your showing that, subject to my lord seeing it, I'm on a slightly more general principle. None of those rules can and do actually suggest that once your lordship locates an anchor in a cadre, the person, as your lordship says, reverse. He is on deputation to center. He is very, very rarely in deputation to another state. I don't know of any.
Normally, in the case of a state,
yes,
once a person has been allocated to a cadre,
yes,
whichever state it is, then that state government decides on the transfers, postings.
It's exactly the same in the three cadres here.
Now, will the same principle apply to the union territory like Delhi is the question?
AGMUT, DANIX and DANIX. They are the three principal.
Right.
It's the same. They are allocated
but
to
that,
us.
Dr. Simi, that now when you say it's the same, that's a matter of your ipsidixis.
No, that
we want to see. You want
that I'll be showing the rule. I'm not come to the rule.
Statutory provision because they will shed light on what it is.
No, therefore that I'll be dealing with. I'm just saying your lordship would have to have a very different kind of. I'll be showing the rule. Lordship will take it. I'll be coming to the rules. But your lordship would have to have a very different kind of an exceptional service created for the states, where there is a deputation to the center and a cadre for the state, versus wherever a UT comes, there is no cadre, there is no deputation to the center, and a specific provision created to have a different scheme. That is all I'm saying at the moment. That is not so. Your lordship is not.
We want to know.
I will show that.
Because that statutory regime will be of some significance actually.
That is dealt with.
See,
that is fully dealt with. So one is lordship.
In your turn, before you conclude today,
no, I'll be coming to that. It's directly dealt with my submission.
What we will see in that is, we want to know who will be the cadre controlling authority, which the rules will specify.
As in all states, same thing. Same thing. I'll show that. As in all states, there is no special scheme created for UTs in that, which inhibits or prohibits what I am asking for, namely control on the civil service serving my state or my UT.
Right.
That's the only point. Now, your lordship has done with yesterday. My next submission are a few submissions on the Balakrishnan report. I've got about 6-7 points. I'll give them one by one. The first submission today is on Balakrishnan report. That what I've just said was about yesterday. Now, this Balakrishnan report was nothing but it was headed by somebody else, by Justice Sarkaria earlier. Then he took some other commission. So Mr. Balakrishnan is an advisor to the Home Ministry. He is chaired it. Now there are 4 or 5 reasons I want to put out in sequence for your lectures. Reason number 1 is the first reason my lord saw yesterday why the Balakrishnan report is of not much value.
What does the Balakrishnan report really say on services?
Yes. I'll be reading the statement. They said, well, in para 8.1.2, I'll be taking a lordship to it in a minute. Let me just give a lordship the submission.
81.2 of your submission.
No,
No,
very.
no, in the Bala report. I'll show them. So, Manus, my submissions are before I take a lordship there. Firstly, Manus, Balakrishnan report is of no relevance today because of the first set of reasons my Lord saw yesterday. A constitutional amendment came with limited A to 3 exclusions, only 3, 1, 2 and 18. B to discretionary powers and C to reference on disagreement. Balakrishnan report, which pre-exists, cannot go beyond that. Number 2, the second reason why the Balakrishnan report is wrongfully made the basis of the input notification is that it makes an error saying, fundamental error, conceptual error, that services can be only of 2 kinds. One under the union and one under the state. And there cannot be services under the UT. This is a fundamental conceptual error. Dr. Speaker, note the point, I'll show the pages.
Will you repeat yourself, Dr. Singh?
I beg what?
You please.
Yes. So the first reason is that Balakrishnan never anticipated that the constitutional amendments structure of 239AA would exclude only 3, nothing else, and 1 discretionary and 1 reference to disagreement. So, Manoj, it has been overridden, it has been supplanted by the constitutional amendment. It can have no relevance today. That is the point your Lordship covered yesterday with me. The second reason why the Balakrishnan report is of no significance is because of a fundamental conceptual error that services will be either of the union or of the states and no third entity, UT, can have services. The third reason, I'm just itemizing things, you should find it convenient, then I'll show the pages. The third reason is that the Balakrishnan report, in so coming to this fallacious conceptual conclusion, completely ignored, if your Lordship were a bench, it would be called per inquiry. Bala report is not a bench. A 4-judge judgment of your Lordships in Prem Kumar, which specifically reversed the High Court, specifically, which held there are only 2 services and UTs can't have a service. Completely omits to mention Prem Kumar Jain. It shows Manoj that Balakrishnan is very infirm on this aspect. Fourthly,
Yes.
which is important, the basis of Prem Kumar Jain is the joint cadre point I just said. And specifically, it contemplates that a joint cadre will be between a UT and the central government. Oh, sorry, UT and a state. Or it could be theoretically 2 states also. And finally, fifthly, it is for this combination of reasons that your Lordships in paras 276 and 277 of the Constitution bench specifically say that we will not take the aid of Balakrishnan, and to quote and unquote, there is no necessity to be guided by the report of the committee. This again is, Malas, a covered area. Your Lordship doesn't have to go beyond or before or after. Now just see these 5 points very quickly. First point, my Lord asked me, where is the Balakrishnan report on this subject? That is in your Lordship's first compilation.
2366.
Para 8.12. And that is your Lordship's larger page, 2438, 2439, 2439. Again, there'll be a 4-page difference maybe for the index. This is the relevant part of Balakrishnan report, 8.1.2.
2370 it starts, right?
Bookmark.
Where do you want us to see?
Bookmark.
Page,
Bookmark 33.
At 2443.
the report starts as per your index at what page, please? This is.
243.
2366 it starts. It's not relevant, Manoj, because the Lordship goes, it's a long report as usually reports are. Lordship may straight away go to 2, 4. That's right. So 8.1.2 in that page.
8.1.2.
Once my Lord has it, I'll read it, please. May I read, please?
Yes.
May I read? Entry 41 of the state list mentions State Public Services, State Public Service Commission. Obviously, this entry is not applicable to UT because it mentions only state and not UTs. This is the binary distinction. Very simplistic. This is the fundamental error of the input notification. It mentions state, can't cover UTs. This view is reinforced by the fact.
Don't mind if you can read
This-
the first para also.
Very
You
well.
don't have to.
Certainly, I'll read.
8.1.1.
I'll read from 1.1.
There is a
The question of control over the service personnel and the input notification, nothing but picking this up and writing it in the notification. This Balakrishnan report, which has been rejected by our constitution bench, is the pickup in the, actually reiterated in the question of control over personnel serving in the Delhi administration was examined by us carefully in view of its obvious importance in the context of evolving a scheme for representative form of government of Delhi. When dealing with the legislative powers to be conferred on the proposed legislative assembly, we recommend that such powers may extend to matters in the state list and the concurrent list. We have already explained in the preceding chapters the need for restricting such powers to matters in those lists in so far as they are applicable in relation to UTs. We have also explained the scope of important reservations in this behalf. Entry 41 of state list mentions,
Yes.
Entry 41 of state list mentions state public services, state services commission. Obviously, this entry not applicable to UTs because it mentions only it's very simple and precise, and I will say directly, Manoj, directly.
Mr. Solicitor expressly said that he's not relying on that.
I'm not relying.
No, that's the beauty of it, Manoj. That's the
I
beauty.
will rely upon it for giving a context as your law.
That is the beauty of it.
To be done contextually. That's all.
Manoj, that is the beauty of it. You cannot elaborate, so you elaborate in a different way.
But it doesn't really matter.
What is happening,
It's a matter of interpreting. You will look into it.
The point, this exact paragraph, 2 sentences of this virtually are exactly the basis of the input notification.
But
Without saying that I rely on Balakrishnan report.
Balakrishnan's report was prior to the constitutional amendment.
Yes,
That cannot now determine
That's right.
the nature of the amendment. We have to decide it for ourselves.
Manoj, therefore, my lord,
At the highest, this is like, it's not even statement of objects and reasons of. Convention.
no, but Manoj, there is one more thing.
These are preparatory documents.
Entirely. I bow down entirely. But in my learned friend's written submissions of 90 pages, Balakrishna report is given pride of place. I mean, I can only go by what is given to your lordships, fellows. Number 2, Balakrishna report, the essence of 8.1.2 is found in the notification. Now,
You have shown us the
You-
para and you have told us why it should not be
so
written.
you are saying that I'm not lying by calling it Balakrishna.
Pedestal that we have to,
Yes.
take, it's not like a statute or something.
Exactly, it's an
It's a
external aid.
review of an officer who has,
Well, ultimately, the reasoning is the same. There are 2 services, central government and state. There is no UT.
but another thing, merely because Balakrishnan is wrong, that doesn't mean that the notification is bad.
No, obviously not. What is that?
Whether the notification is bad or not, we have to decide.
I am showing Manoj the entire case in the written submission. My learned friends, Manoj, saying today it doesn't rely, written submission has got 20 paras of Balakrishna report. That's all right. I mean, ultimately, we have to meet a case. Now,
Neither the notification is not really the subject matter, it's the constitutional interpretation. That's what matters to us.
In any case, Dr. Singhvi, the very para you're reading goes on to state that the reasons that weighed with that in that report was Article 239. There was no 239A anywhere.
That I said, Malas, they are relying upon that. Now, Malas, kindly come to Prem Kumar Jain, 1976, 3 SCC 743. Bookmark.
Page.
This is, Malas, your lordship's page 4142, maybe 4146. Because
1976.
Well, this is 4142. The citation is 76, 3 SCC 743. Four judges, your lordship sometimes has.
Violation page.
4142, which could be 4146 with the index. Bookmark is 52.
There used to be a lot of four-judge benches, particularly in the
Yes.
50s or 60s. So if there was an odd judge, you had to put him in the bench of three, so it became four. That is the only reason why four sat.
But there is nothing really wrong even today, Wallace, if your lordship does have for whatever exigency. Your lordship doesn't normally have, but there is no
Practical problems, sir.
There may be some dissent, etc. but that can.
Your lordship's workload is so much more that your lordship would rather have two benches of two each than one of four.
Absolutely.
Because the one of four is neither a constitution bench nor a three-judge bench. So why should your lordship, Wallace, if in that sense, waste two judges in a bench, if I may use that phrase? Now, Wallace, Justice Shingle starts the judgment. These appeals by certificate are directed. This is important, Wallace, what they reverse from the High Court. That's why I'll read para 1 and 2 first. These appeals by certificate are directed against the judgment of Delhi High Court, 25th September, allowing civil writ. The High Court has quashed the order of the central government notified in so-and-so Gazette, dated January 13, as well as the scheme for the formation, kindly mark this, as well as the scheme for the formation of a joint cadre of the IAS, hereinafter referred to as the service, for the UTs, very important, and has held that the formation of the Delhi Himachal cadre of the service was ultra vires the constitution. On the ground, Himachal is not a state. That's the short point. And directly, therefore, relevant. Directly, the principle is relevant. A new cadre of the service was constituted for the UTs of Delhi and so that time when Himachal was a UT. And recruitment to that cadre was made directly without complying with the requirement of Rule 4, which prescribed. The rules were amended on December 21 by providing for a joint cadre in relation to the Union Territories and the Northeast Frontier Agency and the central government formulated the aforesaid scheme to extend the Delhi Himachal Pradesh cadre, that is the joint cadre, to all UTs by absorbing the officers of that cadre and by appointing to it officers of the Indian Frontier Administrative Service and all other Union Territories at its initial constitution. The joint cadre for all the UTs was brought into existence from January 68 under so-and-so, dated January 13. Now, Ms. kindly read. The petitioners in the High Court challenged the creation of the new joint cadre for all the Union Territories and the appointment of some of the respondents. It was urged in the High Court that the constitution of the new joint cadre was illegal as it was contrary to the provisions of Article 312 and the All India Services Act of 1951, as it was not common to the union and the state, inasmuch as a UT was not a state. And the recruitment of respondents concerned to the joint act and now your lordship may come straight away to para 5. They start with Balus 358 of the General Clauses Act and all that. I will not read it, your lordship is aware of it. Straight away come to para 8. May I read? It follows, therefore, that as from November 56, when the Constitution's 7th Amendment Act came into force, the President had the power to adapt the laws for the purpose of bringing the provisions of any law in force in India into accord. It was under that power that the President issued the Adaptation of Laws Order of Justice, which, as has been shown, substituted a new Clause 358 in the General Clauses Act, providing inter alia that the expression state shall, as respects any period after the commencement of the Constitution, mean a state specified in the first schedule to the Constitution and shall include a UT. State shall include a UT. It cannot be said with any justification that there was anything repugnant in the subject or context to make the definition inapplicable. By virtue of 372A, it was that definition of the expression state which had effect from the first day of November 56, and the Constitution expressly provided it could not be questioned in any court of law. The High Court therefore went wrong in taking a contrary view and in holding that UTs, this is the finding, High Court is reversed. The High Court therefore went wrong in taking a contrary view and in holding that UTs are not state for purpose of 312 and the preamble to the Act of 1951. That was why the High Court erred in holding that the definition of state in the Carter Rules was ultra vires, the All India Act, and the Constitution, and that the Union Territories Charter of the Service was not common to the Union and the states. It's common to Union and states, means common to Union states and UTs within the meaning of 312, etc. And the central government could not make the IAS rules, etc., as there was no government, as there was no such government in the Union Territories. Now, let's see. The one is Balakrishnan report. Oh, I'm sorry. Sorry. One is Bala report.
State.
parts of the constitution which for specific purposes define things. There are many other section clauses I have noted. For example, your lordship got GST in 2016. Your lordship specifically added GST provisions to make UTs covered. That was only for the purpose of GST. Otherwise, again, it's the same thing. Your lordship had to amend the entire 7th schedule. There are other provisions elsewhere for specific purposes.
So 246A came in, 269A came in.
Had to, Malas. Otherwise, your lordship would have a same that 368 amendments and all that. Therefore, Malas, now, Prem Kumar, one is Balakrishnan. Your lordship has observed that his prior and report doesn't bind your lordship is interpreting, so I'm leaving Balakrishnan. Second is the premise underlying the notification of only 2 services. That is also wrong, is what I'm saying. The premise underlying, forget Balakrishnan report, I understand, the lordship, there may be an error in relying on something.
Of course, you have Prem Kumar Jain, but then you have a 9-judge judgment in NDMC which says state does not include a unit.
No, straight away, Manas. NDMC I'll be dealing with. NDMC doesn't deal with this subject. Your lordship, the beauty of this is, NDMC is dealt with by your lordship in the constitution bench.
I read.
Separately, NDMC, this is a totally different question. That's one of the points I'll be dealing with. Your lordship may take it. NDMC does not at all dilute any of my arguments. And your lordship relies upon NDMC to come to the conclusion. Therefore, Manas, if your lordship in a constitution bench explains these judgments, how many times, of course, the iterative process can go on. Your lordship can have 7, 9, 12, but that would not be really, unless
Dr.
glaringly wrong is said by a lordship.
All this in the context of the Balakrishnan report.
No, I'm not leaving the Balakrishnan. I'm saying the premise of the notification is also the same. That there are 2, forget Balakrishnan.
Yeah.
The premise of the notification that there are 2 services is what I'm assailing. I entirely take the cue from my lords that Balakrishnan, though it finds some 10 paragraphs in my learned friend's written submissions now and today, but since he disclaims reliance on it, I also leave it. But well, certainly, the basis of the impute notification is as a binary bifurcation. That is wrong. And Prem Kumar Jain also says it is wrong. That's all I'm saying. Now, Malas, kindly conclude this part with your lordship's findings on this at para 276 and 277, just for completeness. I know your lordship is not relying on it, but your lordship should know these paras. Of the Constitution bench at 4789. 4789. Para 276.
4789.
That could be 4793. It is not as if my learned friend's client has not been relying continuously on Balakrishnan, including today's written submissions. Not, after all, lordship is not devoting all these paras for nothing in your judgments.
Para?
276 para is at 4789. Internal page is 643 of the SCC. May I read it with your lordship's permission?
Yes.
Yes.
We had stated earlier that Mr. Maninder Singh, learned additional ASG, Additional Solicitor General, had urged that the report of the Balakrishnan committee should be taken off as an aid to interpret the constitutional provisions. And he relied on 7, 8 cases. And then, Manas, they quote from one of those cases, 8 cases. 277. There can be no quarrel about the proposition that reports of the committee enacting a legislation can serve as an external aid for construing or understanding the statute. However, in the instant case, as we have elaborately dealt with the meaning to be conferred on the constitutional provision that calls for interpretation, there is no necessity to be guided by the report. So that covers this point. I now come to a very important, conceptual issue, separate issue now, which has got some very interesting phrases, including from something I found out about the civil service from a UK, very interesting website. So Lordship may, he calls it serial monogamy. I'll come to that, can I?
Serial?
Civil servants as serial monogamists. I'll deal with that. Lordship may find it interesting. I mean, it's all persuasive value. Lordship may not use it, but the title of my submission now is, it's more conceptual and jurisprudential. Westminster model,
yes,
collective responsibility and aid and advice.
You're reading somewhere?
No, now I am making my next submission. The heading of my submission is the concepts, how they interrelate on collective responsibility in the context of a Westminster model and this aid and advice. They're all the same. Westminster model, parliamentary British, democratic model, aid and advice. Your Lordship may only note the paras, don't read them. Paras 8 to 11 of my submissions deal somewhat with this, but what I'm now saying point-wise will be better to go in that sequence, not the way it is put there. Now, let's the first of the points under this head. I've only got 3 or 4 points here. But it's 239 AA bracket 6 and 4 may be seen. They directly constitutionally ask your lordships to go back to the concepts of collective responsibility and aid and advice. Just glance at 239 AA.
Two.
239 AA. First C6.
Our constitution bench judgment specifically refers to aid and advice.
I'm reading that paragraph. Therefore, this is a very important part of it. Actually, 90% plus of this is covered, according to me, in various paras of lordship. Therefore, I'm under each head. I'm coming to our lordship bench immediately after this. Council of Ministers shall be collectively responsible to the Legislative Assembly. And just glance at 4, just above that. There shall be a Council of Ministers. This is a typical Westminster model, collective responsibility, aid and advice. There shall be a Council of Ministers consisting of not more than 10% of the total number of members of the Assembly, with the Chief Minister at the head to aid and advise the LG in exercise of his functions, etc. Except where he requires to act in his discretion, which you also will not consider. Now, the implications of this collective responsibility, governance in Delhi, is what my lord focused on and will now focus on again in this case, focused on in the 2018. As your lordship goes into this, your lordship will remember my ladder again, which I'm at the risk of repetition again repeating. Collective responsibility in the larger sense is the ladder: civil servant, responsible to the minister, accountable to the minister, minister accountable to the legislature, through the legislature accountable to the people. That's the fourfold arrow. According to me, your lordship's constitution bench, especially some very, very interesting paras in the judgment of my lord, Justice Chandrachud, as he then, already conceptualize and, more important, synthesize these 3 concepts: Westminster model, collective, and aid. So let us turn first to that straight away. Your lordship's judgment, first para would be 318, and that your lordship will get 4814. In fact, your lordship titles it collective responsibility.
1 minute.
Correct.
Not only the analysis, but the synthesis is very interesting. The internal page is the internal page 668. 668. May I read?
Yes.
Justice Shah has got it.
Yeah, 1 minute.
The title is collective responsibility.
Oh,
Justice Burari has got it.
yeah, got it.
Responsibility. Collective responsibility is a cornerstone of the Westminster model. Initially developed as a constitutional convention in Britain between 1780 and 1832, it began to appear in textbooks in 60s and 70s. In 1867, Walter Bagehot, in his classic work, The English Constitution, called the House of Commons as the real choosing body, which decides the path that the nation would follow. The consequence of such a systemic expectation in the British parliamentary system, Bagehot declared, was that the public can, through Parliament, turn out an administration which is not doing as it likes and can put in an administration which will do as it likes. The responsibility of ministers was set up as their liability to have all their public acts discussed in Parliament. The cabinet was defined as a collective body bound together by a common responsibility. Later, Lord Salisbury formulated this comment. For all that passes in the cabinet, each member of it who does not resign is absolutely and irretrievably responsible, and that he has no right afterwards to say that he agreed in one case to a compromise, while in another case he was persuaded by one of his colleagues. It is only on the principle that absolute responsibility is undertaken by every member of a cabinet, who after a decision is arrived at, remains a member of it, that the joint responsibility of ministers to Parliament can be upheld, and one of the most essential conditions of parliamentary responsibility established. Ministers were liable to lose their offices if they failed to obtain the confidence of the House of Commons. In Dicey, it is propounded, well-established law that the Crown can act only through ministers and according to certain prescribed form, which is absolutely required, the cooperation of some minister, such as Secretary of State or Lord Chancellor, who thereby becomes not only morally but legally responsible for the legality of the act in which he takes part. Hence, therefore, in effect of the Crown itself is brought, under the supremacy of the land. Behind parliamentary responsibility lies legal liability, and the acts of ministers, no less than the acts of subordinate officials, are made subject to the rule of law. This fixed the responsibility of the cabinet for the general conduct. Then I'll skip 320, come to 321. Collective responsibility is comprehended in two aspects. Collective responsibility of ministers for the policies of the government, individual responsibility of ministers for the work of their government. Then your Lordship has put Geoffrey Marshall's three principles underlined, identifies three strands within this principle. I'll not read it, but they are rather interesting. Confidentiality, unanimity, confidence, etc. Finally, now come to 325.
325, correct.
There is a direct relationship between the principle of collective responsibility and government accountability. The relationship is conceptualized in the Oxford Companion. Accountability can be defined in terms of outcomes rather than processes. It also includes the criterion of responsiveness to changes in circumstances that alter citizens' needs and abilities. In other words, accountability refers to the extent to which actual policies and their implementation, kindly if you bear in mind from my perspective, which can only be an issue to the civil service, coincide with the normative ideal in terms of what they ought. In this broad sense, accountability amounts to evaluating the nature of governance itself in outcome-oriented terms. Then what is 327? Collective responsibility also exists in situations where there is no knowledge of the action taken by subordinate officers, that is well as the civil service. Governing is a complex affair. Hundreds of officials in dozens of departments may make many decisions on a day. These officials are also part of the executive, and ministers are responsible to serve in their departments. Ordinarily, ministers busy themselves with policy. Usually left to officials over whom ministers command little or no oversight. Yet when they act, subordinates notionally do so on behalf of ministers. Ministers therefore cannot seek nor can they absolve themselves by their officers. Both inside and outside Parliament, they are accountable for their departmental shortcomings. My lords also put it in the old days by a principle of anonymity. The civil servant is anonymous, the buck stops, and the person who takes the rap and the fall is the minister. That's the principle. This is similar to what your lordship has quoted here. Then, I'll skip some paragraphs and come to 331. My lord cites the 7th judge in Karnataka, 1977 for SCC, and then says, explain the substance of a government's collective responsibility. All the ministers are treated as one entity. A government could stay in office only so long as it commands the support and confidence of majority of the members of the legislature. The government is politically responsible for the decision and policies of each of the ministers and of his department. The sanction against any government action was held to be embodied in the principle of collective responsibility, which is enforced by the pressure of public opinion, expressed specifically in terms of withdrawal of political support. The object of collective responsibility, my lord, then quotes that. Then it was 334.
Effectiveness.
Collective responsibility represents a seminal principle for modern parliamentary democracies. Collective responsibility of the Council of Ministers ensures accountability to the legislature and to the electorate. You are negating bonus for Delhi. If in 239 AA you do not give that collective responsibility, I am giving notionally. But the implementation of that below me by the officers, and then the buck stops with me, that you are taking away.
Read further.
Collective responsibility governs the democratic process as it makes a government liable for every act it does. It envisages that a government works effectively to ensure and fulfill the interests of the public. It purports to ensure transparency in government decisions. Collective responsibility rests on the foundations of constitutional morality, which reflects constitutional ethics. Well, I think this is a very, very plenary and a very inclusive approach by our lordships.
Effectiveness.
Effectiveness, well, implementation, effectiveness, efficaciousness. Why did your lordships create 239 AA? I'm asking myself just for a second. Your lordship had no need to create some duties with legislatures at all. You have so many duties without legislatures. Then having created duties with legislatures by parliamentary legislation, why did you make a constitutional amendment? Because you wanted to meet the criticism that the impulse of the people, the will of the people is reflected in the government of Delhi. You therefore give it collective responsibility rightly, in the wider sense in which my lord uses it. You give it all that panoply, but the collective responsibility can't work because efficaciousness, effectiveness in implementation, which must rely only on the civil service, are substantially de facto absent. Now, kindly link it with aid and advice, and I'm very happy that your lordship has dealt with aid and advice immediately in the next section. So your lordship is linking it into a larger whole. Kindly see that. Because that is the aid and advice which I am a UT, no doubt, with exclusions. But I am a Westminster model. I give aid and advice to the LG every day. I am a chief minister. I am a government. I am ministers. We are supposed to give aid and advice. It's not that your lordship is abolishing Westminster by excluding 3 subjects. It may be truncated, no doubt. Truncated doesn't mean dilution to vanishing point or exclusion. Collective responsibility under our constitution is based on a slightly modified version of the British cabinet system. There is a direct relationship between collective responsibility and the form of government envisaged by the constitution. The president was designated as the titular head of the government. The founding fathers and mothers, this one I have not read in a long time. Perhaps now people will be more careful.
That's for the first time, not long time.
No, I'm saying even after this, I'm not.
Yeah,
that's true. The president was designated as the titular head of government. The founding fathers and mothers of the constitution adopted the convention, which made the president generally bound by the advice of the council of ministers. This was explained by Dr. B.R. Ambedkar while introducing the draft constitution.
The reason why I use the word mothers is that otherwise the role which was played by many of the women members of the constituent
yes,
has
not
been adequately emphasized.
And they were all
people like Dakshini, Valuda. I mean, they were outstanding individuals in those days.
So many.
These women really contributed to the drafting of the constitution.
And your Lordship is right.
Extraordinarily, of course, we focus on Dr. Ambedkar, he was the architect, but then we also focus on Dr. Munshi or Sir Alladi Swami Iyer.
No, relative to one relatively
younger, even though recommendations or the suggestions were rejected, but
so many of them.
The person who was a eminent Urdu lyricist, he gave several suggestions.
The very fact that these women existed, some of them with very eminent husbands, but they had their complete own identity in their own right. Durgabai Deshmukh is an example. There are so many more. And they fought for causes, sometimes not in consonance with what their equally eminent husbands were standing for. And therefore they found a place in the assembly. Somebody wrote an article, I'm not able to remember, but it's long ago, which has tried to survey and says the vast majority of the world calls it motherland. barring a few countries which call it fatherland. Germany, of course, is an outstanding example, but there are a few others. The vast overwhelming majority is motherland.
But I was referring to Hasrat Mohani. He's very popular as a Urdu lyricist, but he had to say something about on every subject. Most of it may not have been accepted, but he contributed. He was not a silent member of the Constituent Assembly.
So, Your Lordship ends on this after quoting Dr. Ambedkar. Just see that quotation, the italics portion, the italicization is by my notes, not by the SCC.
It is merely.
The President of the Union will be generally bound by the advice of his ministers. He can do nothing contrary to their advice, nor can he do anything without their advice. The President of the United States can dismiss any secretary any time. The President of the Indian Union has no power to do so, so long as the ministers command a majority in Parliament. Next line. A democratic executive must satisfy two conditions. It must be a stable executive. It must be the responsible executive. Unfortunately, not possible so far to devise a system which can ensure both in equal degree. In England, where the parliamentary system prevails, the assessment of responsibility of the executive is both daily and periodic. The daily assessment is done by members of parliament through questions, resolutions, no confidence motions, adjournment motions, and debates. The daily assessment of responsibility, which is not available under the American system, is felt far more effective than the periodic assessment and far more necessary in a country like India. The draft constitution in recommending the parliamentary system of executive has preferred more responsibility to more stability. And this is not abstract. Your Lordship is quoting and writing this in the context of the NCT judgment. Same to 3999. Then,
Actually, then
340,
343.
342, if Lordship will come for a minute. 342. Justice Lokur, while delivering the concurring opinion in Navagrevya, opined that the absence of expression is individual judgment makes it apparent that the governor would always be bound by the aid and advice of the Council of Ministers, except in matters where he is permitted under the Constitution to act in his discretion. Collective responsibility and aid and advice are mutually reinforcing principles. That's the linkage, that's the synthesis, which is very important. This is the synthesis. Each of them and both in conjunction affirm and enhance the democratic values on which the cabinet form of government is founded. Collective responsibility ensures that government speaks as one political entity which owes allegiance to the elected representatives of the people. By ensuring that government is responsible in its decision-making to the legislature, the principle of collective responsibility fosters a responsive and accountable government. Now, kindly read. Modern government, with its attendant complexities, comprises of several components and constituent elements. This is important. They include ministers who are also elected as members of the legislature and unelected public officials who work on issues of daily governance. Discussion and dialogue are accepting of dissent. In a system of constitutional governance, collective decision-making must allow room for differences. A synthesis can emerge in government when political maturity and administrative wisdom combine in arriving at acceptable solutions to the problems of governance. Collective responsibility allows for and acknowledges differences in perception and ideology. Yet what the doctrine does is to place a decision taken by a constituent part of the government as a decision of the government. All ministers are bound by the decision taken by one of them or their departments. In terms of its accountability to the legislature, government is treated as one decision-making unit so that politics of decision-making and administrative divergence do not dilute from the responsibility which the government owes as a political unit to the legislature. This year, Lordship brings together the entire ladder which I was saying. This is crucial to ensuring that government is responsible to the aspirations of the people in whom political sovereignty resides. It's an extremely important, actually, I read the other paragraph, this leads up to this, the heart of it. And then when it's 345, the doctrine of aid and advice enhances the commitment to the same democratic values which form the basis of collective responsibility. The mandate that a titular head of the government must act on the aid and advice of the Council of Ministers ensures that form of democratic governance is that the decision-making in the name of a titular head is subservient to its substance, which mandates that the real authority to take decisions must reside in the elected arm of the government. The real authority to take decisions must reside in the elected arm of the government. The doctrine of aid and advice enhances accountability and responsive government. Besides representative government, by ensuring that the real authority to take decisions resides in the Council of Ministers, which owes ultimate responsibility to the people through a legislature to whom the Council is responsible. Collective responsibility in the aid and advice doctrine must not be considered as disjunctive. I would very strongly, for my purposes, underline this. But together constitute integral parts of discourse in ensuring the strength and commitment to democracy. Because all of it is important, but 344 and 345, 343 and 345 are the heart of the matter. Just see one para of Justice Mishra in this connection. Chief Justice Mishra, as he then was, at page 4770.
Chief.
Yes.
Para 208 in the same judgment
Page
of Justice, Chief Justice Mishra's judgment. 4770.
Yes, 477.
Internal page 624.
Dr. Singhvi, I think the content of para F relating to the nature of the executive power is also very important.
My apologies,
You
because I'm
see that.
interested in trying to.
Because that's how the link forms, no? Because ultimately we are talking about exercise of executive power.
Your Lordship is referring to which parameters?
The page 679, F, nature of executive power. In that you can just.
679 of the SCC.
SCC.
Yes.
Your continuous page 4825. Because it gets linked to the executive power.
675 is it?
679,
Yeah,
para 346 onwards.
Yes. I've got it.
348 you can actually read
Yes.
at page 4826.
It is not already touched with that arrow.
You want
Scrolling
page number?
takes time.
You want PDF page?
348.
Para.
May I read 348 please? Before elucidating the nature and ambit of the relationship between the Council of Ministers and the Lieutenant Governor, the Lieutenant Governor and the President, it will be necessary to advert to some of the other provisions of 239AA which have a bearing on these relationships. The Lieutenant Governor, as we have noted earlier, is appointed by the Minister.
No, the executive, how the executive power works.
Is appointed by the President under 239(1), read with 239AA1. The Chief Minister appointed by the President, while the other ministers are appointed by the President on the advice of the Chief Minister. They hold office during the pleasure of the President. The concept of collective responsibility of the Council to the Assembly is expressly embodied in clause 6, which I read to your lordships. Comparative analysis of the provision of the Constitution relating to the Council of Ministers in the Union and of the states indicates that in case of NCT, 239AA is engrafted the fundamental precept of collective responsibility of an elected government in a cabinet form of government to the elected legislature, creating an executive power in government which is coextensive with the legislative power of the elected legislature and the collective responsibility of the Council of Ministers to the legislature are intrinsic to the cabinet form of government. Whereas my apologies, I should have read this myself. But this
357, 4830. So it is connected now. It is connected to the exercise of the executive power.
Then, Your Lordship,
The collective
352,
357.
307.
357, yes.
Para.
I've got that. Just give me a second, Melissa. These provisions of the Constitution institutionalize a relation between the President and the Union Cabinet and reaffirm the position of the President as the titular head. The President...
Parliament, the Central Council.
Yes.
Not the state.
No, with respect. My Lord is citing all of them in a state 239 AA case. My Lord is adapting it for the 239 AA case and minus the excluded powers. The Westminster model with collective responsibility is fully adopted. It's fully adopted. I learned when we argue that to the contrary, because it is not at all limited to just the presidential form of. These provisions of the Constitution institutionalize the relationship between the President and the Union Cabinet and reaffirm the position of the President's titular head. The President must act on the aid and advice tendered by the Cabinet. The executive power of the Union is co-extensive with the legislative power of Parliament. In a cabinet form of government, it is the Council of Ministers which owes collective responsibility to the House of People. Collective responsibility as a constitutional doctrine ensures accountability to the sovereign will of the people who elect the members of the legislature. This is very, very important. Though all executive action is expressed to be taken in the name of the President, and the orders and instruments made and executed in the name of the President are authenticated in the manner prescribed by the rules, the constitutional position of the President is of a titular head. The use of the expression the exercise of his functions in 74(1) is formalistic in nature, since the substance of executive power is vested in and conferred upon the government constituted through the Council of Ministers, which owes collective responsibility to Parliament. The proviso to 74 stipulates that while the President may require the Council to reconsider his advice, once that has been done, the President is bound to act on the advice tendered after reconsideration.
Dr. Singhvi,
Yes.
now if you can go to para 360, where we have tried to now bring the balance between the union territory. To what extent does it adopt the cabinet form of government, and to what extent
Would my laws
it
also
sort of gives greater powers to the lieutenant
I'm
government?
grateful. Would my laws just
360,
spend half a minute on 358 also? The position of the President as a titular head of state is evidence that the constitutional provisions is defined. I'll leave that on the state, not that state.
Let's go to 360.
Then 359 is governor and state, come to 361. While assessing the status of NCT, certain significant aspects need to be borne in mind. 239 AA is a result of exercise of constituent power under 368. By and as a result of 239 AA, special provisions have been made for the NCT. These are not an emanation of an act of ordinary legislation. For the NCT of Delhi, the exercise of the constituent power has resulted in a constitutionally entrenched status, both for the legislature and for the Council of Ministers. The Assembly is elected by the process of direct election. This is very, very important. The Assembly has the power to enact law in respect to matters in the state list of the 7th schedule. That is, save for 1, 2, and 18, and the other 3. Yet, while the Assembly, which has been conferred on the Executive Assembly to extend to state list, save for accepted entities, and the concurrent list, Parliament has been empowered to legislate both on matters falling within the state and concurrent list. Parliament possesses overriding legislative powers over matters falling in both the state and concurrent list. This is a complete harmonization, I would say. Then, 239 AA4 provides constitutional status to the Council of Ministers and embodies the entrenched principle in a cabinet form of government that a titular head of state acts on the aid and advice tendered by his ministers, which owe collective responsibility to the state legislature. In setting up a structure of governance in which there is a legislature elected through the process of direct election and an executive arm which is collectively responsible to the legislature and which in the discharge of its functions tenders aid and advice to lieutenant government on matters which are coextensive legislative power. The Constitution has incorporated the basic principles of the cabinet form of government. The adoption of these special features of the cabinet form of government in relation to NCT must weigh while interpreting 239AA.
Now 361.
Then
Yeah, the-
361. At the same time, constitutional scheme indicates several features in relation to the NCT, which have all resulted in the conferment of a constitutional status, which falls short of the trappings of full state. They include the following. The position of the NCT is subsumed under Part 8, which applies to UTs. Delhi is and continues to be a UT. Every UT is under 239, administered by the President, acting through an administrator. The administrator appointed under 239 is designated as the LG for the NCT. 239 is the source of constitutional power to appoint the LG for the NCT. The position that the application of 239 is not excluded in relation to NCT is made evident by 239AB. In a situation in which the President is empowered to suspend the provision of 239AA, where the administration of the NCT cannot be carried on in accordance with article or of any law made in pursuance of the article, the President is empowered to make consequential provisions for administering the territory in accordance with 239 as well as 239. Hence, the provision of 239A cannot be read disjunctive from 239(1). The administration of a union territory by Parliament acting through an administrator is firstly subject to parliamentary law and second to such extent as he thinks. Hence, the nature of the administration of a union, including NCT, is subject to these two provisions. The position of the NCT as distinguished with the constitutional position of a state finds expression in contrast between 239AB and 356. Upon the exercise of power under 356, the President can assume to himself the function of the government of the state and declare that the powers of the legislation of the state shall be exercisable by or under the authority of Parliament. In contrast, 239AB empowers the President to suspend the operation of 239AA or of any provision of law made under it, and to therefore make consequential provisions for the administration of the NCT in accordance with 239 and 239AA. While emphasizing the binding character of the aid and advice tendered to the President, or as the case may be the Governor, the constitutional position in relation to the NG contains a distinct variation. 74(1) embodies, in relation to the President of India, the binding character of the aid and advice tendered by the Council of Ministers by specifying that the President shall, in the exercise of his functions, act in accordance with advice. Upon the President requiring the Council to reconsider the advice, the President is bound to act upon the advice which is tendered. Similarly, in the case of governors, 163(1) provides for a Council of Ministers to aid and advise the governor in the exercise of his functions, except that the governor is required to act by the Constitution to exercise his functions in his discretion. 239AA4 incorporates in its substantive segment the constitutional principle of aid and advice which the Council of Ministers tenders to the LG. But in relation to the advice tendered by the LG, by the Council of Ministers, the proviso to 239AA4 has engrafted a special provision which does not have a corollary in 163. While under 163(1), the governor is required to act upon the aid and advice tendered, save in matters which the Constitution entrusts to the discretion. The proviso to 239AA4 contemplates an area where the binding character of the aid and advice tendered to the LG is lifted. So I'll just pause here. Till now, just give me 5 seconds. Till now, my lord is saying it's the same as precedent, minus 3 excluded areas, 1 discretion, and 1 disagreement. 5 things. That's what my lord is saying. That's the 5 special features of a UT under 239AA. Now let's come to 362. In resolving the area.
Comes up here, and your 3 principles are restated. The trinity of the 3 principles that you are mentioning, the commencement is restated here at 362.
Yes, that's 362. I'm grateful. That's why I paused there. Total is 5. Those principles now come together in 362. So your lordship will not be, I'm saying whether the lordship should not allow the incremental wrongful expansion of these 5 exceptions to make a UT into nothing more than a fiefdom of the central government. Is that simple? There's no doubt. This is state. This is UT Delhi minus 5. Nobody's cavilling in that. But now by incremental notifications, executive orders, directions, you can't increase those 5 to the universe. That's the short point. Now kindly see that, as my lord Nasra puts it, 362. In resolving the area within which the LG can refer the difference of opinion with the council of the NCT to the president, it would be necessary to balance on the one hand the constitutional principle of cabinet form, while on the other hand, leaving open the latitude which has been created by Proviso 4. You already have so much power as a provider. The former consideration would need the court to pursue a line of interpretation which does not detract from the fundamental principles of representative government. I'm very grateful, Manoj. This is what I was reading in the collective responsibility part. An elected government reflects in a democracy the aspirations of the people who vote to elect their representatives. The elected representatives carry the responsibility of giving expression to the political will of the electorate. In a democratic form of government, real power must subsist in the elected arms of the government. The ministers of government are elected representatives of the people. They are accountable to the people through their collective responsibility to the legislature. As a collective entity, the Council of Ministers owes responsibility to the legislature. The relationship between the Council of Ministers and the titular head is governed by the overarching consideration that real power and substantive accountability is vested in the elected representatives of the people. The principle of aid and advice is in a constitutional sense intended to strengthen the constitutional value of representative government and of governance, which is accountable and responsive to the electorate. While bearing these fundamental constitutional principles of democracy in mind, a balance has to be struck with the second of the above elements, which recognizes the special status of NCT. The NCT represents, this is extremely important, the NCT represents the aspirations of the residents of its territory, but it embodies its character as a capital city, the political symbolism underlying national governance. The circumstances pertaining to the governance of NCT may have a direct and immediate impact upon the collective welfare of the nation. This is the rationale for the exclusion of the subjects of public order, police, and land from the legislative power and necessarily from the executive power of NCT. These considerations will necessarily require a careful balance between the two principles. Each of the two principles must be given adequate weight in producing a result which promotes the basic constitutional values of participatory democracy, while at the same time preserving fundamental concerns in the secure governance of the nation.
I try to draw balance. The judgment. One, that the Article 239 AA and the 69th Amendment, which brought it about, preserve the basic principle of the cabinet form of government, collective responsibility, and aid and advice. These are the bedrock of representative democracy.
Parliamentary democracy.
Parliamentary democracy. And we have therefore said that 239 AA embodies that. At the same time, we said that this is really a constitutional scheme which is created for the governance of the national capital territory.
So by exceptions,
which in that sense, of course, is not merely a matter of the residents of that territory, but symbolizes the entire nation.
That's why
it's the nation in proper governance. And therefore, we said that on the other hand, that's the reason why three subjects have been carved out: public order, law and order, and land. Because that's something which really, in that sense, represents the national interest in the secure governance of the national capital territory. So you really need to balance both. You can't read one to the exclusion of the other. You need to bring a harmony between the two. Now, the question which we really have to confront is control over the public services. Does it exclusively lie in one? Does it exclusively lie in the other? Or is there a median?
Therefore, Manoj, let me just, what is implicit, but also not said explicitly just now, implicit.
The concern that there should be a representative government would warrant that control over the public service must exclusively vest with the Council of Ministers once the officers are allocated to the Union Territory. Because according to you, it is only through controlling your officers who are allocated to the Union Territory that you can implement legislation and policies. Otherwise, you'll be bereft over the control and therefore you will have no accountability to the legislature and the people.
More than that, I will have no governance tools to
But then
satisfy the
we
electorate.
also need to ask ourselves to at what point of time does control over the public services really go into the second realm, the latter realm of, a proper national governance, or does it go into the?
Therefore, my lord has
That's
got,
the
that's the issue.
area which we need
With
to
great
reflect.
respect, that's the issue. I bow down. Now just note three sentences here. What is implicit in all this, fellows, if your lordship's paras, these paras, some places even explicit, that otherwise, why does your lordship start with the president and the Union advice, central government? Your lordship starts those paras with that. Is that the Westminster parliamentary government has to have the titular head and the governing head. I'm not talking of NCT, just leave it aside. Then having described that as Westminster, as President, as Article 73, etc., etc., your lordship turns to Delhi. It is because Delhi is a dual role of a national capital that not 3 but 5 exceptions, that delicate balance the Honorable Chief Justice just now said, is struck by the text of 239 AA itself in the first place. The delicate balance is struck A, by excluding 3, B, by giving something which your lordship doesn't have in the central government, namely reference on a disagreement, C, by giving a further power of acting in discretion, which is there in some governors, etc.
One way to harmonize would be to say that control over the public services, insofar as it relates to the 3 accepted subjects, excluded subjects.
That is certainly one way, Mills. That is the correct
That will
way.
not vest with the.
Sorry for the
That will not
interruption.
vest
It
with the
is
Delhi government.
already, it's not their case also, they should get it. It's not their case also, number one. Number two, while earmarking, my lord, possibly, my lord, did not include 3 excluded categories explicitly, and insofar as category.
That is going to be your subject.
Mills, can I just...
Insofar as
can I
it's
just-
applicable.
Now, Mills, it comes back to the same notification. It comes back to 2 phrases. Insofar as, and Mills, there are only 2 services. It comes back to... Anyway, let me, Mills, not my chain of thought is a little different. So first is presidential normal Westminster. Second is the 5 exceptions in NCT. Your lordship will note this. Third, all your lordship sayings about will of the people, electorate, the very rationale of giving a legislature to Delhi are negated if your lordship will not appreciate the reality as is being sought by the impugn notification to suggest to your lordships, that once any civil service is allocated to a state, and for present purposes, your lordship must hold the state to be equal to UT. Otherwise, there is no governance. Once it is allocated to a UT, in this case, the power of appointing, transferring, appointing to post X or Y, disciplining, acting, terms of service of that person have to be with that UT.
Now, Dr.
Now,
Singh,
fourth.
we've seen, but now this is 2 areas which we need to wrap up.
Yes.
Before we conclude your submission.
Those rules.
One, the statutory rules govening these services,
Yes,
which
yes.
we'd like to see.
Yes.
And then finally, we'd like to see what is the difference between Justice Sikri and we need to see that.
Justice?
Between Justice Sikri and Justice Bhushan in the 2-judge bench, because I mean that led to the 3-judge and then now
Yeah,
the
that's right.
Bhushan bench.
So, may I just, I'm
So,
saying this.
I think now the judgment we have covered.
This is covered. I'm ending this, just note 208 para of Justice Mishra, just one para,
You want to see
just
that.
for completing.
Yes.
I'll be going in that sequence, only excursus, formalist, federalism
page
for
is
just
that?
2 minutes, and I'm coming in that same.
What page is that?
PDF 4774. Mark 4770.
228, right?
208.
Or 208.
Show me that, show me. 770 निकाल दो, 770.
Yes, sir.
The legislature, the Legislative Assembly, Council of Ministers, and the Westminster-style cabinet brought by the 69th Amendment highlight the uniqueness attributed to Delhi with the aim that the residents of Delhi have a larger say in how Delhi is to be governed. The real purpose behind the Constitution Amendment of 91, as we perceive it, is to establish a democratic setup and representative form of government, wherein the majority has a right to embody their opinion in laws and policies pertaining to NCT of Delhi, subject to the limitations imposed by the Constitution. For paving the way to realize this real purpose, it is necessary that we give a purposive interpretation It's very, very important. This objective of lordship has to be actually implemented in real life, not in an ivory towerish sense as the central government believes. It is necessary we give a purposive interpretation. So the principles of democracy and federalism, which are part of the basic structure, are reinforced in their truest sense. As I'm ending this section by a quick short reference to that book about civil service. Just 2 minutes. Now, this is bookmark 3-4. And why it's interesting is only because of the way he puts it. This 3 portions take only 2 minutes. Well, this is a civilservice.org.uk by a former civil servant. The page is 2557. Understanding the civil service. I'll read a few lines here and there. And I'm not going to take more than 2 or 3 minutes in this. Civil servant, civil service numbers. Then let us come to the next page where he says civil servants, ministers and parliament. That is 2558. Civil servants work within a constitutional framework known as the Westminster model. May I read that, Lordship Gadan? 2558. Your Lordship is at bookmark 34.
2562 of PDF, right?
2562, 4 page. 2562 with the index count.
562. 2558 is the running number.
2558 is actually 2562 of your Lordship's PDF. It's 4 pages ahead.
What is this book about?
This is Manus civilservants.org.uk. It is a website, Manus, updated and maintained, and a very well-known and very eminent and popular website by a senior former civil servant in UK. On civil service meaning in the Westminster system, I literally take only a few lines from here and there. May I read? Justice Raswa has got it. Now, the civil servants, ministers and parliament. Civil servants work within a constitutional framework known as the Westminster model, which requires them to be politically impartial while being principally accountable only to ministers within the current government. This is a reality your Lordship knows. This is something basics have to be again underlined because this is not true in case the
2558.
civil servants, ministers and parliament. Civil servants work within a constitutional framework known as the Westminster model, which requires them politically impartial while being principally accountable only to ministers within the current government. What is the point of having the notification which will make them unaccountable to them? They also work within a wide range of ethical and other constraints which are taken very seriously by both senior staff and the wider public. This includes an ethical code which requires officials to be honest, impartial, challenging, collaborative. One of their key skills is to achieve their objectives while observing both the letter and the spirit of their various objectives.
Yes.
That's
2563, which is 2567, I think, in your lordships.
25. What is it?
2563, which is your lordships 2567. PDF 2567.
Yes.
Your lordship has seen the opening where he says this is the system. and
one minute.
structure. The culture of civil service. is-
One minute.
My apologies, my apologies.
2567.
6-3.
2563.
Printed 63, continuous pagination is, I think, 67.
But that's why they are serial monogamous.
No, it's just a.
So long as the representation, so long as the relationship lasts, loyal to only one. Once the
That's the
relationship
meaning of a
changes, we
state
switch to
frame,
loyalty.
because their loyalty is to be to the governance and the constitution. You kindly see this. I mean, it's just by ending on this point, it's only the last point of this. Then I come to federalism and then I come to that rules. The culture of the civil service is quite unlike that of other organizations in the UK.
You know, very beautifully put. 2567. The culture, please read. Yes.
The culture of the civil service is quite unlike that of the other organization in the UK. Civil servants are expected to be highly professional, serial monogamists, intensely loyal to their current ministers. This is important, Manoj. There is no loyalty where there is no control to even transfer. There is no serial monogamy, Manoj. There is consistent monogamy with somebody else outside the room, but ready to switch allegiance whenever there is a change of government. And they are simultaneously expected to respect the vital role of parliament. The relationship between civil servants, minister and parliament was highly respected and emulated to a certain or greater lesser extent in many other countries. It still has its admirers and nonetheless has many critics who argue it is outdated. I'll leave this first. Then just see 2565, 2 pages. Above, under 1.2, para is 1.2.
UK Constitution.
Just above 1.2.1. Legitimacy and democracy. May I read that? Page 2565.
Yes.
Just above para 1.2.1, 2 paras above that.
Yes.
Legitimacy and democracy are maintained because ministers are answerable to parliament and the House of Commons is elected by the people, subject to complying with the laws made by parliament. Day-to-day decisions are taken by ministers and if necessary by the whole cabinet and implemented by a politically neutral civil service. Put shortly, there is a simple change of command. Accountable to ministers, civil servants accountable to ministers, ministers accountable to parliament, members of parliament accountable to the constituents, and so on. Now, one more thing was 2569, para 1.3. 2569, para 1.3. The lengthy Armstrong memorandum, first published in 85, summarizes the duties and responsibilities of civil servants. Most important parts are, civil servants are servants of the crown. For all practical purposes, the crown in this context means it is represented by the government of the day. The civil service as such has no constitutional personality or responsibility separate from the duly constituted government of the day, which has to be the NCT government. You are alter egos of the government, not of some other master outside. It is there to provide the government of the day with advice on the formulation of the policy of the government, to assist in carrying out the decisions of the government, and to manage and deliver the service for which the government is responsible. The civil service serves the government of the day as a whole. That is to say, Her Majesty's ministries collectively, and the Prime Minister is the Minister for the Civil Service. The duty of the individual civil servant is first and foremost to the Minister of the Crown, who is in charge of the department in which she or he is serving. Each minister is responsible to Parliament for the conduct of his department and for the actions carried out by his department in pursuit of government policies or in discharge of responsibilities laid upon him as a minister. A minister is accountable to Parliament in the sense that he has a duty to explain in Parliament the exercise of his powers and duties and to give an account to Parliament of what is done by him as a capacity, in his capacity as a minister or by his department. Civil servants are responsible to their ministers for their actions and conduct. The British Civil Service is a non-political and professional career service subject to a code of rules and ethics disciplines. Civil servants are required to serve the duly constituted government of the day of whatever political complexion and so on. Now, Manoj, I turn very briefly to a few paras which we've left out on federalism, and then I'll come towards the federalism is important, Manoj, because this whole thing is lying in the context of two shared sovereignties. This part is over. Westminster, collective responsibility, area and advice is over. Now your Lordship is broadly put the thing of federalism. Now my Lords will just note the points and then I'll read a few. Lords will capture the essence. But my submission is one, but incidentally, it's very interesting. I once Googled the Constitution and one of the largest constitutions of the world. It has federal or federalism several times, but not a single word federalism as we understand it, from preamble to the end. All those references to federal are to the federal court. So, Malas, it's the only concept which your lordship did not enact in the preamble,
Yes.
did not put in the text of the entire constitution, but is held to be a basic structure. It's a very interesting, Malas, and a rightful paradox. I mean, I entirely support it. Federalism should be and is a basic structure, at least, of course, since Bommai. But it doesn't find a text in the preamble onwards. And your lordship immediately finds hundreds of federal coming, that's for the federal court. No federal otherwise. Now, Malas, federalism is vital because it is telling you how to share sovereignties. National is first, but regional is no less important. Regional, local, state level. It is this dual manifestation. There are, as I said yesterday, Manas, there are multiple manifestations down to municipality and your lordship's panchayat chapter part now. But we are not going there. It is this dual manifestation which, Manas, is the heart of democratic will. Because all democratic will can't be centered on one sovereignty. That's point number 3. Point number 4. In that sense, Manas, we the people create 2 governments at least, as I said, multiple. Central government and state and union territory governments. So this manifestation is a dual or a triple manifestation of the popular will exemplified by we the people. The 4th aspect or the 5th aspect under this head, Manas, is that there is no more important concept than federalism in a diversity context. Actually, people talk of federalism even in Western countries. In Germany is an example. England is the opposite example. But that federalism is nothing compared to the diversity we have here. There are homogeneous people, language, style, habit, religion also. With the diversities we have in this country, federalism is the most self-preservatory basic structure your lordship has found. It is actually more of self-preservation. Your lordships cannot have a country like India except by a very, very real, in-spirit federalism perhaps. Fifthly, Manas, the priorities, the purposes, and the philosophies. This is not intended, there is some alliteration there. Priorities, purposes, and philosophies of these 2 or 3 sovereignties which manifest through federalism are not only bound to be different, they are intended to be different. That is the true meaning of how federalism accommodates these different priorities, different purposes, different philosophies. The union territory government may have a different priority in terms of policy bills. Give ABCD and focus more on that priority and less on X, Y, Z. And the central government is equally entitled to focus more on priority X, Y, and Z. One more on welfare, one more on infra, one where so many, I don't itemize. You manage these differences of priorities, of purposes and philosophies because you say that federalism will deal with the concept of multiple sovereignties, giving enough space in your house to you without interference. Federalism is nothing else but a very, very nice constitutional concept of live and let live in the political and the governance sense. And live and let live in a real sense, not live and let live in a formal sense. Now let's just turn to para 51 to 56 of my Lord Justice Chandrachud's judgment in that matter. This is the same, no. I'm sorry. This is called a judgment called Mohit Minerals, which is relatively recent.
CV2.
And it is, what is the bookmark number? Oh, I see.
2-1.
We filed it in the convenience volume 2, Malas, the second one. Bookmark, yeah, bookmark.
We give the citation.
Bookmark 1, the first case, and it is at page 74 of the second volume.
Citation.
Citation, yes. Citation. Sorry, apologies. Scrolling takes some time.
Bookmark 74 or page 74?
Bookmark 1, page 74 is the relevant portion.
Got it.
Whereas 2022,
Very first case.
10 SCC 700, decided by a 3-judge bench was headed by my lords on 19th May 2022.
This is Union of India versus Mohit Mendes.
That is, where is it, Dr. Singh? I stand.
Volume 2, very
The
first.
second volume,
Oh, volume 2.
Very first case.
Yes.
Relevant para. Mr. Sanghvi,
and your lordships would well turn to
which at the relevant para?
51 at PDF page 74 and SCC page 773. Your PDF page may be 4 pages ahead. but-
Yeah, 70.
Yes.
Referring to para.
This is all NCT issues, 239 AA issues. Underlying it, the heart of it is federalism. May I read this?
Yes.
Murari has got it.
Which paragraph here?
Para is 51
51.
at page for this PDF 78 and SCC 773.
Yes, 78. Yes.
The
Well-
dual, I'm reading this. The dual federalism model or the autonomy model views the constituting units of the center and states as autonomous, independent, and competing units. This model is also termed as comparative federalism, where the constituent units compete with each other. Proponents of the cooperative federalism model argue it is a mistake to view each unit as a separate autonomous entity. According to the theory of cooperative federalism, integration and not autonomy is the objective that federalism seeks to achieve. Integration and not autonomy is the objective that federalism seeks to achieve. While dual federalism is termed as layer cake federalism due to the delineation of structures of power, cooperative federalism is known as marble cake federalism due to the integrated approach of the federalism. In NCT, the court has observed that India follows a model of cooperative federalism, where the union and state governments need to iron out differences that arise in the course of the path of development. Chief Justice Mishra said this. Thus, the idea behind the concept of collaborative federalism and negotiation is negotiation and coordination, so as to iron out differences which may arise between the union and the state governments in their respective pursuits of development. The union government and the state government should endeavor to address the common problems with the intention to arrive at a solution by showing statesmanship, combined action, and sincere cooperation. In collaborative federalism, the union and state government should express their readiness to achieve the common objective and work together for achieving it. In a functional constitution, the authority should exhibit sincere concern to avoid any conflict. Provision as to the source of authority, we are absolutely unequivocal that both the center and the states must work within their spheres and not think of any encroachment. But in the context of exercise of authority within the spheres, there should be perception of mature statesmanship, so the constitutionally bestowed responsibilities are shared by them. Such an approach requires continuous and seamless interaction. The Indian Constitution has sometimes been described as a quasi-federal, a constitution with a centralizing drift. Because when the constitution is read as a whole, the union is presented a larger share of power. Instances of this centralization drift can be traced to Articles 234. However, there are instances of 6A where the center and the states are conferred equal power, merely because a few provisions of the Constitution provided. Merely because, important, a few provisions of the Constitution provided the union with a greater share of power. The provisions in which the federal units are envisaged to possess equal power cannot be construed in favor of the union. The union and the states have a simultaneous power to legislate on GST. GST Council has the power to make recommendations, etc. I'll skip this one. 53. The federal system is a means to accommodate the needs of a pluralistic society to function in a democratic manner. It's very important. Pluralism and democracy. Representative government. It attempts to reconcile the desire of unity and commonality along with the desire for diversity and autonomy. Democracy and federalism are interdependent on each other for their survival, such that federalism would only be stable in well-functioning democracies. Additionally, the constituent units in a federal polity check the exercise of power of one another to prevent one group from exercising dominant power. The Indian Constitution, though necessarily federal, does confer the Union with a higher share of power in certain situations to prevent chaos and provide security. And that's what the Constitutional Assembly said also. However, even if the federal units are not entirely autonomous, as in the traditional federal system, the units still wield the power. The relationship between two constant units that are not autonomous but rely on each other for their function is not in practice always collaborative or cooperative. If the states have been conferred lesser power, they can still resist the mandates of the union by using different forms of political contestation as permitted by constitutional design. Such contestation furthers both the principle of federalism and democracy. When the federal units are vested with unequal power, the collaboration between them is not necessarily cooperative. Harmonized decision thrives not just in cooperation but also on contestation. Indian federalism is a dialogue in which states at the center constantly engage in conversations. Such dialogues can be placed on two ends of the spectrum: collaborative discussions that cooperative federalism fosters at one end and interstitial contestation at the other. Then, Your Lordship quotes on interstitial as uncooperative federalism. That's rather interesting. They argue that the states which possess lesser power could use license dissent by using regulatory gaps or by civil disobedience, etc. Can I skip that and come to 55? Such form of contestation, as the authors term it, uncooperative federalism, is valuable since it is desirable to have some level of friction, some amount of state contestation, some deliberation generating froth in our democratic system. Therefore, let us don't think that because there is power at one level, at the other level, the power is any less democratic. Therefore, the states can use various forms of contestation if they disagree with the decision of the center. Such forms of contestation are also within the framework of Indian federalism. The GST is not merely a constitutional body restricted to the indirect tax system, but an important focal point to foster federalism. One of the important features of Indian federalism is fiscal federalism. This is one of the 6 tendencies which my lords have generally, not your lordship judicially, but experts, academics have said. Inadvertent or unintended federalism. What in 2022 your lordship is in India is far, far more federal than when India started in 1947 or 1950. One of them is fiscal federalism, where your lordship devolves 43 to 45% of all the funds and grants to the, and money is where the shoe pinches or the shoe. So money is important. It used to be 30% when we started. And that is in the context of GST. I'll not read it. But may I end on federalism by saying there cannot be a teleological purposive interpretation of 239 AA. A teleological purposive interpretation, which my Lord Justice Mishra has already said in that paragraph, without factoring in the genuine, legitimate spirit of federalism as an equal sovereignty with the constitutional limitations put there. So, now, I turn to a couple of shorter points, and then I'll come to those rules. One is, NDMC, just note, I don't even need to read it. It is bookmark 38. Open it. It's bookmark 38 in the second volume. This one which your lordship is handling.
2100.
Yeah, don't need to go to it. Let me just point out first. Citation is 1997, 7 SCC 339. Please note 2 things. One. The issue is important. What was the issue, Manas? May I formulate in 2 lines because that will make it shorter. Your Lordship may want to note it down. The issue was squarely and admittedly this: whether municipal taxes imposed under the NDMC Act, whether municipal taxes imposed under the NDMC Act, on state government properties in Delhi, in NDMC area, amounts to union taxation and is therefore exempt under 289 of the Indian Constitution. I repeat, it is important one is whether municipal taxes imposed under the NDMC Act on state government properties in Delhi, falling in the NDMC area, some 40 odd kilometers, is union taxation and therefore exempt under 289. The majority simply held very simple thing, Manas. Yes, exempt if non-commercial state property. No, not exempt if commercial property. That is the entire. Second point, in sequence. Second, NDMC had nothing to do with the functioning of the Delhi Assembly or the NCT government vis-a-vis the central government. Nothing. Thirdly, your Lordships has noted the scope of NDMC in Manas, the judgment itself. In the second one. Convenience first. Huh? Paramelas. Just give me a minute. But have it. Open it is. Well, it is on your page 4765, internal page 619 of the Constitution Bench of NCT. May I read para 195?
1 minute.
Which volume?
The original NCT Constitution Bench is using.
Volume 1.
Volume one.
One.
Volume one.
Using them.
Who are one?
102. NDMC matter.
No,
57S.
No, not NDMC. I'm on NDMC as dealt with by a Lordship's Constitution Bench. So the Constitution Bench deals with it in para 195.
Page.
At page 4765 of the first convenience volume of Lordship is using. Internal
475.
6.
It could be 4769. PF 4769.
Para 195.
195. But please keep in mind the issue I gave you, Lordships, and the finding of NDMC. In that light, read this. So, well, Chief Justice Mishra says this. Now, let us allude to the post-69th amendment. 9-judge bench in NDMC, wherein Justice Reddy, speaking for the majority, after taking note of the rivalized submissions pertaining to union taxation, we call him Palaman, which you can't play down this. Referred to in Sea Customs Act, said this. In the year 91, the Constitution did provide for a legislature for the Union Territory by the 69th Amendment. But even here, the legislature so created not a full-fledged legislation, nor did it have the effect of assuming that it could lift the NCT by Delhi from UT category to the category of states. All this necessarily Then after that, he goes on to say at para 155, quote 155 of the NDMC. It is necessary to remember that all the UTs are not situated alike. There are certain UTs, Andaman, etc., for which there can be no legislator at all as of today. There is a second category of UTs covered by 239A, which applied to Himachal, Manipur, Tripura, Goa, Daman, Diu, Puducherry. Now, of course, only Pondicherry serves in this category, the rest having acquired statehood, which have legislatures by courtesy of Parliament. Parliament can by law provide for constitutional legislatures for these states and confer upon these legislatures such powers as it thinks appropriate. Parliament had created legislatures for these UTs under the Government of Union Territories Act of 63, empowering them to make laws with respect to matters of 3 and 3, but subject to its overriding power. Third category is Delhi. It had no legislatures with effect in 1956 until one was created and introduced by 239AA. We have already dealt with the special features of 239AA and need not repeat it. Indeed, a reference to 239B, read with clause 8 of 239AA, shows how the UT of Delhi is in a class by itself, certainly not a state within the meaning of 246. In some, it is also territory governed by Article Clause 4. Thus, MDMC makes it clear as crystal that all UTs under our constitutional scheme are not on the same pedestal. As far as NCT Delhi is concerned, it is not a state in the meaning of 246. Though NCT of Delhi partakes a unique position for the 69th Amendment, yet in sum and substance it remains a UT, which is governed by 246 and to which Parliament in the exercise has given the appellation of NCT. That's all. Now your Lordship will go to my Lord Justice Chandrachud's judgment, which is at the bigger page number, 4877. I need my notes out this here. It's straight up. Okay. At 451 is the para number. The page is 4877. The PDF page may be 4881. Where my Lord starts with this topic.
There are 450.
451. The decision in NDMC is the title. I'll just include after.
Come back after. Roughly how long now, Dr. Singh?
Well, I'll be for in half an hour, 40 minutes.